Number 801.
Please, Mulad.
801, anyhow, it's coming up on 3rd December.
3rd of December.
Not to be deleted.
Very well. So great. Mulad, this application, Mulad, this is filed for, I have prepared.
Your other matters also clubbed
That-
with that.
that's right.
Both matters will come together. Why didn't
And
you
this
do IA?
application also, Mulad.
Very good. IA also will.
Well, I'm so grateful. Deep
IA to be
gratitude.
listed in.
Grateful.
Item number 1.
This is Milords a transfer petition, Milords from Gwalior to Milords Mumbai.
Yes.
Milords, the complainant, Milords, and all the accused Milords, they reside in Mumbai. Milords, the complainant has also filed one FIR in respect of the same transaction. Milords, that he has also filed in Mumbai. Milords, but only to
Yes.
Milords, the complainant stays in Mumbai. He has filed one FIR in respect of the same transaction against the same accused in Mumbai. Milords, that case is pending. Milords, only but to harass Milords, the accused, this 138 he has filed Milords all the way in Gwalior, Milords. Milords, the transaction and everything they have taken place, Milords, and Mumbai. And Milords, may I just point out few pages of the complaint, Milords, where he has mentioned his own address of Mumbai also, Milords. It is not even his case.
Counter that he does do business in Mumbai also.
Milords, his primary business is in Mumbai. That is what he has stated everywhere.
Let us see what the other side has.
Yes.
You are appearing for the.
Manoj, for respondent number 1, who is the complainant in this case, Manoj. Now, Manoj, this is a check bounce case, Manoj. I maintain the account
If you are doing business in Mumbai,
in
you
Gwalior.
must be maintaining a bank account in Mumbai also.
In Gwalior. In Gwalior.
You don't have a bank account
I
in
have a
Mumbai?
bank account in Bombay also, Manoj.
Then
But the
this
check,
business transaction was in Mumbai.
the business transaction was in Mumbai and Gwalior, Manoj.
No.
My agency is in Gwalior, Manoj.
But you have a business at Mumbai, you have a bank account at Mumbai. Obviously, you're filing it at
No, ma'am.
Gwalior only to
No, Manoj. The check
pressurize the
The
other.
check bounce case was filed in 2017, Manoj. The FIR was filed in 2018. That's number 1. Number 2 is my bank account is in Gwalior. The check was deposited in Gwalior. It was dishonored
Why
in
would
Gwalior.
you deposit a Bombay check, take it all the way to Gwalior and then deposit it there?
Manoj,
Check is issued
do
to you at
business-
Bombay.
I do business both in Gwalior and
Why would you carry a check when you do have a business establishment in Mumbai? Why would you carry a check all the way to Gwalior and deposit it there instead of depositing it at your Mumbai bank account
I
itself?
have establishment
For
both in Gwalior.
obvious reasons. There's no
Manoj,
question.
Milords,
of
may
it.
I just show page 90 for a second? Sorry for the interruption. Just for a second, page 90 of my petition, Milords.
Yes.
Milords, this is the FIR he has filed, Milords, in Mumbai regarding the same
That was
transaction.
later, he says.
It was in
Milords, just see
2018,
his
after 1 year.
statement, Milords. Just
Yeah.
see his own statement. I,
Yeah.
Rahul Kopikar, occupation, Milords, Kalyan contact present in police station and give the complaint that as there is
Where are
Radha
you reading?
gas service agency at Vikroli in Mumbai. This is his own
Vikroli.
Milords statement, page 90.
Yes.
This is his own Milords complaint
Doing
that he is
business.
operating from Mumbai,
Kindly see
Vikroli.
para 6 of this complaint, Manoj, which is at page number 62.
Yes. 62.
Page 62, para 6 and 11, Manoj, I'll read.
Yes.
When the applicant deposited the check in his bank account, which is IDBI Bank, Sanatan Dharm Mandir Road, branch Gwalior, for payment, but the check number so-and-so was returned to the applicant without payment with a banknote, insufficient funds for the reasons mentioned in the bank memo. Then, Manoj, para 11 at page number 64.
Yes.
On the basis of the said check being deposited by the applicant in the bank account in IDBI Bank, branch Sanatan Dharm Mandir Road, Gwalior, the said bank was within the jurisdiction. Well, then kindly see my counter. Page 26.
Yes.
Page 26 is the bank return memo, Manoj.
This is all established.
Yes.
The only issue is whether
Yes.
you're entitled to say that
Manoj, then I am relying.
you are relying on the legal position that
Yes.
if you maintain a bank account, but once you have two bank accounts,
Yes.
and you have a bank account at Mumbai where you do have business, this check is issued to you at Mumbai, given to you at Mumbai.
Yes, ma'am.
You don't deposit it in your bank account at Mumbai. You take the check to Gwalior with you, deposit it there. Your lack of bona fides are on the face of it quite clear.
With due respect, Manoj, the law
By
is.
way of this, sorry, Council,
Manoj,
they are
there,
transferring.
Manoj, may I show one judgment, Manoj? Your lordship judgment.
Judgment, my own judgment is there,
Yes, Manoj.
which is against you.
No, no,
Where
no.
I've said that 406 does permit.
Please, my
no
lords, exactly,
transfer
precisely, my lords.
of Atlanta.
No, Manoj,
Reliance
this is
Atlanta.
Prakash Chimalal said of July 2025.
What does it say?
Because it says that the complaint, because it deals with section 142(2)(a). Now 142 starts with a non-obstante clause, Manoj.
All
And
that
it
has
says-
been
No,
considered.
Milots, 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 Atlanta Milots is very clear, Milots, on that. Plus, Yogesh versus Atlanta Milots has set out the law, Milots.
Atlanta is what, Atlanta is what.
Milots, it
says
cannot override
that
Milots
notwithstanding
406.
this legal position,
Please, Milots.
406 jurisdiction can be
Please,
exercised by the court
Manoj, just
in a given case.
It's just
Sorry,
one-
Council.
then Manoj, in that case, with your permission, Manoj, may it be transferred to Metropolitan Magistrate Court, Vikhroli East. Manoj, the reason is why I'm saying so is because if you kindly see page number 25, which is the check itself,
That was at Vikhroli.
Vikhroli East.
What is the name of the judge?
Manoj, Learned Metropolitan Magistrate Court, Karamvar Nagar, Vikhroli East.
Karam Nagar.
It's Karamvar Nagar.
Kannam, it is
Just give the
pronounced
name.
as Kannambar Nagar.
Karamvar Nagar.
Kannambar Nagar.
Then Manoj, then with consent, let it be
The
transferred.
admitted fact, you want it to be by consent.
Then consent.
Attorney Counsel for the respondent, having filed a counter, states that he has no objection. States that on instructions,
Yes,
again, your client shouldn't come forward and say that I never instructed my counsel to do this.
Manoj,
You're certain?
in 2017, the legal.
Because you're now conceding, do you have the instructions to do so?
Yes, ma'am.
Very, then counsel for the respondent states on instructions that the respondent has no objection. Respondent number one states that respondent number one has no objection. Who are these R2 and 3? Are they
The firm
served?
and the other directors, the firm and the other.
They're served?
Yes,
Yes,
so
sir.
I appear for them.
Manoj, since 2017, they have been avoiding service.
To the transfer of the case, give the details from Gwalior, wherever that is, to this court. Recording the said statement. The transfer.
Manoj, some-
Petition is allowed. Party shall appear before the transferring court.
Highly
on
grateful.
15th December.
Much of it.
Appear before the.
Yes, ma'am.
Highly grateful, Milots.
Item number 2.
Lord, I'm appearing for respondent wise.
Yeah.
Your permission, my lord. Can you see the rejoinder?
In your transfer petition, did you not say that you never lived in Bihar? You never lived together in Bihar?
Yes, yes. Only
You
for
said
3
so?
days, only at the time of marriage. Only
You
3
said
days.
so?
Yes.
Where did you say so? Let us see that first.
Me rejoined also, my lord.
No. First, show us where you said, because I've noted that you said so, but I don't remember which page is it. You stated that after the marriage, you and your wife did not live together in Bihar at any point of time.
Only, my lord, only 3 days.
Where did you say that, guys? Just show us where you said that.
Para, my lord.
There's some reason.
My lord, but see the para 2.
Para
Petition
two.
number 1 married the respondent on 27 April 2022. After the Hindu rites and ceremony at Etna Patna, reside together in Etna. This is the address.
No, you also said that you never lived together in Bihar.
Yes, my lord.
Where did you say that?
Even also my rejoinder also.
If you don't know where you said it, say so, we'll search for it ourselves.
Already.
If you drafted the petition, you should be
Yeah,
aware of where you said it.
I drafted.
Then where did you say it?
Can you give a passover for us?
On page 13,
I will check.
Page 13. Yes.
A, first. The petitioner number 1 and respondent have never so resided in Bihar.
Bihar for last 3 years.
Parent,
This is grounds.
now he's changed. Because she said that they live together in Muzaffarpur.
Even my lord,
They never lived together. Now he's changed.
even my lord, kindly see this annexure 2.
Yeah.
That's yes.
Parent,
Page 13.
Page 13.
Page 13,
Page
this is
13.
ground A. He starts page 12
Yes.
and then page 13, my lords, he has made A and B. In A, top,
Have never co-resided in Bihar. So you made a specific statement that you never resided along with your wife
Yes.
in Bihar.
Yes.
Now
no,
you are changing that.
No. I'm not stating my
So
child.
she has filed a
My
counter
lord,
saying
as
that
per
you
the
lived
point,
together in
I
Muzaffarpur
kindly see the
in
annexure.
Bihar.
Kindly see the annexure 12.
Sorry?
My rejoinder. See the annexure 12 and 14.
So now you are saying that you did live together in.
Only 3 days at that time of marriage, my lord.
She says that you lived together from 2020 till 2024.
Oh, no, lord.
still he is living in
I'm-
Bihar, my lord. We both are IT professionals. We are
Both
working
are
from
working in
home.
Noida.
We are working from home. In
No,
my lord,
no.
Noida, in April 2022.
This
He
wrong
took a flat
statement
on
that
Madam,
you
kindly see
made.
the only annexure 12 of my rejoinder. Her see the location. She claiming the HRA.
Leave her the lie that you started with
No,
in your transfer petition.
my lord, kindly see.
You lied. You said that we never resided together.
At the time of marriage was a 3-day ceremony. Marriage.
Petitioner number 1 and respondent have never co-resided in Bihar. This is a false statement that you made. Once you made a false statement, liable to be non-suited straight away.
But my lord, it's not a false. If you see the.
You are now admitting that you lived together in Muzaffarpur at least for 3 days.
Married only for 3 days, my lord.
For 3 days.
Yeah.
That doesn't amount to co-residing in
Mention
Bihar.
my rejoinder, my lord.
3 days you lived together in
Yes.
Bihar.
At the time of marriage.
That is enough. You made a false statement. Once you make a false statement, no
My
question.
lord, already your own order, lord. See, your own
By
order.
way of
Kindly see
this
the.
transfer petition,
My lord, see
the
the
petitioner
annexure
has
P11. Your
transferred
own order, lord.
case
Your own order for the
Patna,
same title.
Bihar to Karkarduma courts at Delhi. In his transfer petition, the petitioner specifically stated at page 13 of the transfer petition that he and his wife, the respondent, never co-resided in Bihar.
My lord, kindly see
However,
your own order, my lord.
After
Your
the
own
counter
judgment.
affidavit was filed by the respondent, indicating that the couple did live together at Muzaffarpur in the state of Bihar after their marriage. The petitioner husband changed his stand in his rejoinder and now states that they did live together in the state of Bihar for 3 days. A petitioner who approaches this court seeking relief is expected to do so with clean hands and not by suppression or misrepresentation of facts.
My lord, she
The
is residing in
petitioner,
Noida.
on the face of
And
it,
this will
is
be
clearly
even your
found
own order,
to
lord.
abuse the process of this court, as he did make a declaration which is factually incorrect in his transfer petition. On this short ground, the transfer petition is discussed. Interim stay dated 9/7/2025 shall stand vacated.
I'm so blessed.
Be a little careful when you do your pleadings, just for the sake of, just for getting this a stay order, don't lie.
Your own order, lordship. Your own order passed by earlier.
We said that lying is permitted.
Yes,
Yes.
you permitted by you, lordship.
Sorry?
No, lying is.
Permitted by-
Lying is permitted.
No,
We said lying is permitted.
no,
Then-
I'm not lying.
Well, you did lie.
My lord,
There
you
has
see
to
the
matter.
We
PA.
mentioned in the petition that he got
Sorry.
married in Bihar.
Bihar only for 3 days, lordship. It's because
Here's the
of
question. You said you never co-resided. 3 days you lived together, that is co-residing. You didn't get married and leave in the evening.
your own order, lordship.
Next matter.
For the same jurisdiction, my lord.
Counters filed. You filed a counter.
Please, my lord, I am for petitioner.
Yes,
State has filed counter, my lord,
yes.
and there is no eyewitness. It has been stated by the state itself. I have undergone 6 years and 6 months, your lordship. Out of 24 witnesses, only 4 has been examined. And in this matter, my lord,
What was
kindly
the
see the state.
trial?
There are 24 prosecution witnesses, Lordship. 4 has been examined.
4 have been examined out of 24.
Yes, Your Lordship. He's undergone 6 years, 4 months, 17 days.
No eyewitnesses.
No, Lordship. I have gone through.
And what time was she found? Why?
When the father reached the house, she was found on the bed. The accused and all the family members had already absconded. So only the husband's name is there in the charge sheet. The name of the brother-in-law, mother-in-law, father-in-law, and sister-in-law were removed.
Exonerated, your lordship.
They all
Initially,
did.
their name has been mentioned in the FIR.
But the others are all exonerated.
All of them are exonerated except for the husband. When the father reached the place of occurrence, they had all of them had absconded.
And what time was that? The morning, night,
Morning, Lordship.
morning.
In fact, your lordship, deceased has committed suicide because she has not got any child after marriage of more than 7 years. And this is the statement of the father, my lord.
Anti-mortem strangulation is the cause of death,
Yes, Your Lordship.
not hanging. Strangulation.
Strangulation, your lordship. This
Strangulation
is on
is different.
page
Strangulation
19, your lordship,
implies
page 19
use of
statement of the
hands
doctor.
Or a rope, some such implement. She was strangled to death, not that she died by suicide by hanging. Anti-mortem, the postmortem report says so.
Yes, Your Lordship.
Anti-mortem strangulation.
I've also brought on record the doctor's statement from the relevant paragraphs of the case diary. It says.
Was there any rope or something found there?
No,
Nothing of
Your
it.
Lordship. In fact, her bone was
Sure,
found.
is the postmortem report,
Lordship,
postmortem report is also filed?
I have filed the statement of the doctor.
Doctor is there?
Yes.
Where is it?
Your
Lordship.
lordship, this is on page 19, annexure R2, then counter affidavit, my lord.
19.
Page 19, 19.
Last 2 sentences, Lordship.
Died due to strangulation. We will only ask the trial court to expedite the trial.
Lordship, I have already
Very
undergone
because
more.
there's no eyewitness
My,
doesn't
my
mean
lord,
that
my lord, kindly
What?
consider this is not a question. Your
Despite
lordship,
the
your-
length of incarceration suffered by the petitioner. The postmortem report clearly indicates that his wife died by strangulation. And he is the only one facing charges in that regard. The specially petition accordingly dismissed.
your lordship, kindly 1 minute, your lordship, this is your lordship judgment, criteria of judgment, your lordship, when trial has been not concluded within 5 years.
Petitioner.
Kindly, your lordship, consider.
We would,
Kindly,
however,
because
request the trial
petitioner has
court
no
to
criminal
conclude the
incident,
trial
nothing,
as expeditiously
because
as possible,
wife has committed
without
suicide.
granting unnecessary adjournments either to the prosecution.
Your
or
lordship,
the
I am never taking any
accused.
adjournment.
Grateful, Lordship.
Then your lordship, kindly give me liberty, at least if trial has been not completed within certain time, then I
No,
have
no, we
filed
are not
again.
fixing a time frame. It will have to be.
Your lordship, kindly consider, if your lordship
We
dismiss
said
this
that
matter, then
expeditiously,
I will,
thereafter you
your
can
lordship,
file.
then I'm seeking to withdraw my lord.
Item 4, my lord.
Item 4, my lord.
There is a 4.1, my lord, your lordships have issued and tagged it along.
Yes.
If your lordship permits me, give me 3 weeks' time, I'll file a formal counter because the same ground.
Both of them are perhaps
Yes,
don't
yes.
stand on the same footing
Both.
because coexist, no doubt.
Yes,
But the person in the petitioner in 4
yeah.
was out on bail when he's committed this offense. The second man perhaps was not.
I don't know,
convicted
my lord.
earlier.
That's exactly what I want to find
No,
out. If there is any
going by the order also, he said that I have no criminal antecedents. 4.1.
4.1, I don't have the brief, my lord.
You don't have the brief
I don't
also.
have the brief.
Then,
That is why. Or you
or
lordship.
in any event, you're not entitled to. You violate the condition of the suspension of sentence. You've already been convicted.
No, my
Come out on bail and then you violate it.
My lord, it is, I am, the appeal has been allowed, my lordship, in that matter, my lord.
Appeal is allowed. That doesn't mean that you still get the benefit of violating
No,
the bail condition there.
My lord, kindly see the
When
explanation of
you
FIR.
were caught in relation to this offence,
I bowed down, my
you
lord.
were out on bail in that criminal appeal.
My
You
lord.
were out on bail.
The whole FIR
And
is
you are
quoted, my lordship.
stated to have again indulged in the same
For a
act.
moment, my lordship, kindly see
Commercial
FIR.
quantity, 42 kgs,
For a
by the way.
moment. Only FIR, my lordship.
Anyhow,
And
we'll
the
live
counter,
to see another day. Let the counter come in 4.1.
only the
Then
counter.
we'll see. Learned counsel appearing for the state, for the
Statement.
state of Tamil Nadu, seeks some time to file a counter affidavit in SLP criminal number 17208 of 2025. Usual order. Based on 18 December.
Right.
Item number 5.
My lordship, I do allowed to be appearance.
Item 5.
Your Lordship, in item 5, I'm being led by my senior in some medical difficulty.
Sorry?
In item 5, I'm being led by my senior in some medical difficulty.
Difficult. Medical difficulty.
Medical difficulty. I'm praying for some accommodation.
How much time do you want?
Your Lordship, any date next week?
Next week, I am, I should take it up tomorrow, day after, it's Friday, I should take it up. Next week, I am in a difficulty.
They have,
What is wrong with the council?
The matter has been adjourned for 5.
He's having some pain in
4
the
times.
neck. He cannot sit. There's some. That's why he cannot. It's very difficult for him.
Yeah, it's a
I'm in-
302 matter.
I am in lots of time, but it's 1.5 years have gone by almost. 1 year.
It's on 8th December.
So great.
The request to the learned counsel for the respondent.
8 December. 8 December. The lots of fixing 8.
8th is
So great.
Item number 6.
8th is Monday.
What is it?
yes, counter 5.
Let me file an additional document as well, Malach. Stating the stage of the trial, Malach. 11 witnesses have been examined. Now it is at the stage of defense.
11 out of 14 are.
3 have dropped few, Malach.
3 approximately.
Yes, Malach.
So
Now it is
file
at the
is
stage
on-
of
State of
the defense evidence.
defense evidence.
Next date is 27th November. He has 12 criminal antecedents. Malach.
11.
12, 11.
11 or 12?
11, my lords.
11.
It's 11.
11.
My lords, 1 year, 1 month. has
No,
been-
the trial is almost over.
For defense witness.
So of course, earlier NDPS cases also involved cop syrup only, or he was dealing with some other thing.
Malach, that
There were some.
we couldn't get the FIRs.
No, but when you give the details of the
My lords,
earlier cases,
my lords,
you can't
3 of them,
just
my lords, 3 cases.
counter perhaps.
Was IPC. 1 was for the public gambling act. And 2 of them.
3 were NDPS.
Yes, my lord.
Or this is the present case. So 2 other ones. 2 were NDPS. What were the drugs that you were dealing with there? You should know. What was your client dealing with there in those cases?
My lords, 1, what I know of was ganja.
Ganja.
5
Then
5
one?
kgs ganja. And in Drugs and Cosmetics Act,
No, the other NDPS. There are 2 NDPS. One in 2012, one in 2015.
my lords, 2012 one I know, my lords, ganja, it was.
It was an NDPS. He's regularly involved in these activities. Malach. He's selling to the young people, and they are further selling it to the in the society. Malach.
This cough syrup, we are in the process of hearing that batch of cases. 16 bottles.
Malach, it is 1600 grams. So 1 kilo is the commercial quantity. He's caught up with.
No, that you will have to look at the amount of codeine phosphate, is it not?
Malach, there's a judgment. Malach, which
That
says
there
that the
seems to
neutral
be a
substance cannot
notification
be
of the
excluded.
government of India saying that in an
No,
undivided
Dhira Singh judgment.
preparation.
It says that the neutral substance cannot be excluded. It has to be seen.
But
as
if the government itself comes out with a notification,
There's
there's a government notification. Are you aware of that? There's a government of India notification saying that in undivided preparations, if the codeine phosphate is up to a particular level, it will not come within the scope of NDPS.
Even at the
So we don't know what these 16 bottles, how much was the percentage of codeine phosphate?
It makes it worse. The neutral substance makes the drug worse.
Once there is a Government of India notification,
I
you
have
can't
to-
argue
I have-
against it.
Yes,
If
ma'am.
the
Yes.
GOI in its wisdom says that this will not come within the scope of NDPS, so be it.
So I have to see that, but he has prior.
Are you aware of that notification?
Yes, my lord. It
What
says-
does it say? 2.5%.
Yes, my lord.
0.5%. We don't know what the percentage here is.
My lords,
Does it indicate?
Either.
Does your FIR indicate the percentage in the bottle?
No, my lords.
Cough syrup normally contains how much? I don't know.
I have to see. I'll just see and come back.
Most of these are Fensidyl, I think. Fensidyl cough syrup. So immediately, if you can find a medical shop, see how much Fensidyl has.
I'll just find it online. Okay.
You pass it over.
Yes, sir.
May please, Your Lordship.
Counter affidavit not filed.
Please, Your Lords, I appear for the respondent number 2. Your Lords,
R2. Who's appearing for R2?
Your Lords, I appear for R2. The R2 is trying to source some documents. Your Lords, we will do the needful within the week, subject to Your Lordship's graciousness, Your Lords.
State also has not filed yet.
No, Lordship. I'll also need.
Learned counsel appearing for the state of Uttar Pradesh and the learned counsel appearing for respondent number 2 seek some more time to file the counter affidavits. Usual order. List on 12th January.
Highly obliged.
Great. Great.
Adjournment is sought by the learned counsel for the respondent to file a counter affidavit. Usual order. List on. This is a.
Bail minutes. Regular.
What are the offences? Hurt.
It's attempt.
Attempt to murder. Attempt to murder. List on 7th January.
Lordships. Item number 9.
For the accused,
For counter affidavit.
for the accused, I filed my Pagalakama day before yesterday only.
State has filed a counter?
Yes, we have filed
You filed
yesterday.
it.
But I may be granted.
Yesterday?
Yesterday we have filed, it may not be on.
May not be in record.
Learned counsel for respond number 2 seeks some more time to file. You
But
just
first-
entered it.
First opportunity.
You filed your wakala?
Yes, not day before yesterday, it's there in the office.
That he entered appearance day before yesterday and seeks some time to file a counter affidavit. Usual order after that. 8th January.
Like-
If the trial is going on, may not would you lot to consider hearing on that day because the witnesses are now being examined. That's why we.
Lord, I am being summoned as an additional accused in general in CRPC. I was not an accused during investigation even. There was a closure report and.
No, but the order is the template order that is being followed by the Allahabad High Court.
Lord, I.
Somebody needs to tell them to at least change the template once in a while.
That we have unfortunate.
Overcrowding of jails.
I may not be, my lord.
Template orders and transfer
that
petitions is
your
all right. We also follow that.
That your lordship.
But in bail matters, at least you should not be
Lord,
following a
I bowed
template order.
I may not be to send behind bars.
Whether it's a
My lord,
302 matter or a 323 matter, overcrowding of jails.
my lord, that's incorrect. Lord, I bow down, but my lord, the lady accused may not be punished for that. That is the I.
Very well, you file your counter.
I will file our reply. Much appreciated.
Item number 10. May it please, sir. My lord, it's unusually long. My lord, I wouldn't have come and bothered your lordships, but I must tell your lordship,
What is this order though? What are you
My lord,
agreed by?
my
One
lord,
order reserves judgment.
I didn't know how
The
to
other
come, my lord,
order is an
either.
Order of adjournment and you have to file a
My lord,
report.
either I
What is
come
it
in
that you
Article
want us to
32,
do?
my lord, either I come in 32 or my lord, I had to file some SLP. Allow me just one moment to
You
give
are-
your lordship ground reality, my lord.
Reserved, is it?
My lord, it was reserved after 1.5 years. After reserving, it is again listed. When it is
From
listed
filing
in.
of a report, we can't say that.
No, my lord, allow me just.
We
No
have
report actually, my
allow
lord.
some play in the joints even for the high courts. If the learned judge has a doubt and reopens the matter, we are happy to
My
find.
lord, allow me just one moment. Actually, my lord, no report is now taken, and from then onwards, my lord, reserved was on 20th July, relisted on 17th October. After 17th October, it has been listed
31st
now.
October, it's supposed to
Now,
come
my lord,
up. What
5
happened on
times.
that day? What happened on 31st October?
Nothing happened, my lord. Not even taken
The
up.
report was not filed?
Not, my lord, matter not called out. Then after that 4 dates, matter not called out because the my lord court master says this is only for pronouncement and it will be pronounced. So my
Well,
lord,
these
matter
are
is
not
not
orders
called out.
that we can interfere with, Mr.
So my lord, I can only say, my lord, 2 orders I want to show to your lordships, my lord. Punjab High Court itself, your lordships, my lord, said that this practice My lord, Punjab High Court, your lordship said, my lord, and had given a direction, a bail pending since July 2024. Whether, my lord, allowed or dismissed is, my lord, another thing. But, my lord, your lordships have now passed directions, my lord, that it should be decided. Hussain said 1 week. Satinder Antil said, my lord, 2 weeks. Now, my lord, recently, my lord, Justice Bhartiwala's bench said.
High Court, sir. I didn't understand that. You go to Rajasthan High Court, you also before Punjab and
No, my
Haryana.
lord, it's the bail is only before Punjab High Court. Because
No, but
SFIO case is in Gurugram. The
You seem
original
to have-
case is in Jaipur.
You obtained interim bail from Rajasthan High Court on 7th August.
My lord, that's an interim bail application because I'm confined in
That's a
several
different
jails.
case. How is it
Different
that you
case,
are going
Mullah.
before both
No, my
courts?
lord, no, my lord. The High Court has granted bail in all cases to him because of, my lord, peculiarity of situation. He was, my lord, medically ill, is a senior citizen.
Well, he didn't undergo the surgery for 1 year. That's the reason why it was cancelled earlier.
No,
You
my lord,
obtained interim bail on the ground that he's going to undergo that surgery, and then he doesn't undergo the surgery for 1 year. Thereafter,
my lord,
it's
there are,
recalled.
my lord, several,
Again,
he
interim bail
indeed has undergone something, my
by
lord.
the Rajasthan High Court.
What today, my lord, that's
What is
Rajasthan High
happening
Court is not under consideration. Under consideration, my lord, what Punjab High Court sitting over a bail order, my lord, for so long. My lord, I am only telling your lordship, my lord, and making a responsible statement. The matter is not being called out. It is not being called out.
We are not inclined to interfere with the impugned orders in the light of the fact that the Punjab and Haryana High Courts, a learned judge of the Punjab and Haryana High Court seems to have reserved judgment in the matter by the earlier order dated 28/7/2025. But the matter seems to have been reopened for the purpose of enabling the filing of a report. As the learned judge would be pronouncing orders having reserved judgment in the matter, we are not inclined to interfere at this stage. The special leave petitions accordingly dismissed on that short ground. So you can show it to the learned judge and say that.
My lord, I only say, my lord, your lordships, one word, that, my lord, your lordships expect that it would be disposed of. That is enough, my lord. And my lords have made such observations earlier.
Yes.
Only one line, my lord, that your lordships expect that it will be decided, and therefore, my lord.
I'll add that also.
My lord.
And just say that also. And we would expect that the learned judge would be pronounced.
Deeply obliged, my lords. Deeply obliged, my lords. Deeply obliged.
Unknown delay petitions also there. So just say delay unknown, 8 days.
Your Lordship, the present FIR has been filed after an inordinate delay of more than 2 years and 7 months. The petitioner has been arrested after 6 years and 9 months from the date of the registration of the FIR. The other co-accused in this matter, namely Mr.
You were absconding since 2018 though.
Your Lordship, but we were present on the production warrant, on the first production warrant. And Your Lordship, we have
the FIR is of 2018. You were arrested only in June 25.
Your Lordship, but the other main accused have been enlarged on bail in this.
That doesn't mean that you just. Where did you go off to?
Your Lordship.
Charge sheet is also filed, but you have not filed a copy of the charge sheet, so we don't know what it says against you. So this selective filing of documents is of course very popular here, but we'll have to take at least draw an adverse inference once you don't file a relevant document. You've not filed a copy of the charge sheet. You say that the charge sheet is filed.
Your Lordship.
You're obviously shown as an accused there because you've been arrested. So we don't know what the charge sheet says against you. You don't want us to see it.
Your Lordship, please give me please one short date.
No. That building up the case as you go along, that is also not permitted.
Your Lordship, but we have been enlarged on bail in other similarly situated.
We find no good ground and reason to interfere with the imperial judgment passed by the High Court, especially petitions accordingly dismissed.
Item number 12.
Adjournment is sought by the learned counsel for the respondent to enable him to file a counter affidavit. There's no interim order. No interim order.
Lordship, in item 12, I beg to appear on behalf of the petitioner.
Date I'll use, 19.
The TCR also was requisitioned in the.
Sorry?
In item 11, TCR also was requisitioned. That may also be taken.
In item?
11.
11?
Sorry, item 12, my lord.
12?
TCR also was requisitioned, but it is not received so far.
Yes. That was asked for.
Yes, ma'am. With a previous order, it was asked.
Which order was that? Maybe asked for e-copies of the trial court records.
Yes.
So that was long ago.
Long
Not been requisitioned till.
It was requisitioned, my lord.
What does the office report say?
From the office report, para 5. Requisitioned as early as in 2110.
Registry shall follow up and secure the trial court records from the High Court, public trial court, as expeditiously as possible.
Public.
Pleadings may also be completed, Lordship.
Sorry?
Pleadings may also be completed. Counter was directed to be filed, not yet filed.
Pleadings? What
Yes.
pleadings?
No, Lordship had recorded in the last order that counter was to be filed. They prayed for time,
All
not yet
that
filed.
to do. That is the reason why we are adjourning the matter, to enable the
Yes, Lordship.
file a counter.
Great.
Great.
Rejoined
It's
order.
also incomplete, I was told.
Sorry?
Service is also incomplete.
Service is incomplete.
That's what I was told.
Yes.
Office report says,
We are taking fresh steps on it by the state today.
Service shall be completed on the unserved respondents by the next day. Who's unserved?
2 and 3.
2 and 3.
2 and 3. 1 and 3.
Sorry, 1 and 3.
We have preferred 2.
1 and unserved respond numbers.
Great.
13, adjournment is sought by the learned counsel for the respondent on the ground that the learned counsel on the ground of personal difficulty. However, we find that the counter affidavit has not been filed. File a counter also, please. We find that the counter affidavit has not been filed till date. Needful in that regard shall be done within 2 weeks. Rejoinder thereto, if any, may be filed within 1 week thereafter. Within 2 weeks thereafter. List on 27th and
Please.
Item number 14.
In this matter, replies are waited.
My lords,
R2 is not served.
I beg to appear on behalf of R2.
R2 is
By
it?
the petitioner. My lords, I'll file my wakalatnama during the course of the day.
No.
However, last order indicates, my lords, that we can make an attempt for settlement. Should the other side be willing, my lords, I'm willing to participate in the mediation before Supreme Court, my lords.
Yes.
In fact, the notice itself says, notice order.
We fix a date, Milos, for that.
Very good. Mediation. Okay. This, both parties are here.
Yes.
I appear for respondent number 2, Khushbu Garg.
No, where is she?
My lords, she's in there.
Rishikesh, Milos.
Rishikesh.
Yes.
Sorry, Rishikesh, my lords.
Weekend would be better or a weekday? She works?
First one can be virtually and then they can decide the
Very
mode of mediation, my lords.
Then 3rd December at 11 a.m.
Very well.
Physical requirement, my lords, they can be the first of it.
Sorry?
Should there be any physical requirement?
Thereafter,
My lords, if my lords can indicate it in the order, my
you need the expenses
yes,
to
the
be taken.
expenses to be paid. My lords.
If she needs to come physically, you will bear the expense.
I don't mind, but she is updated with the maintenance part, Milord, and her aunt is
You want to
residing.
settle or you don't
Yes,
want to
certainly.
settle?
I'm agree with you.
Then you should, that order also.
Grateful, my lords.
Very well. Obliged.
Item number 15.
Wait, please.
Yes.
If your lordships could grant me a short passover. Actually, I'm led by Mr. Deshmukh. He is on his.
You've received a copy of the counter?
Well, that the counter has been received by them. They had taken some time to file a rejoinder. However,
Not filed though.
No, not filed.
You don't need to file a rejoinder?
I have no instructions as to that, my lords.
Well, you did take time on 15th April for a rejoinder,
I'm aware, my lords.
but then we take it that you don't want to file a rejoinder.
No, my lords, I would like to seek some instructions from Mr.
Why didn't you ask for the instructions before you came here then?
No,
If you're aware of the fact that the earlier order records that you were granted time to file a rejoinder, then you must ask your colleague, your senior, whoever is, you're attached to the office of the arguing counsel.
Yes, my lord.
Then why didn't you ask him then? You feel shy in front of your senior. Scared or shy?
A little bit of both.
Both, is it? But you're brave before us. It should be the other way around.
Forgive me, my lords. A short passover would be.
What for? Again, your senior will come and ask for time to file the rejoinder. We find that the rejoinder has not been filed till date. Last opportunity is granted to do so before the next date of hearing. List on 90. This is perhaps a matter for hearing. You want some monetary benefits or something?
The petitioner, yes.
20th. 20th January.
Get obliged.
Please, I'm appealing for the private respondent, Your Lordship.
Yes.
Your Lordship, his son died due to negligence in the army hospital. Item 69 of Your Lordship.
Some judgment is also there is what they are said.
Yes. In item number 16, I am requesting for a passover. We are led by Mr. Banerjee. This matter is in court 8.
You are for the petitioner.
For the respondent, Your Lordship.
You should be here. Unless you've changed your identity, you want to go there. You want to pass over?
And I will be having difficulty in case it is passed over. There will be.
Then we'll give you another date. When do you want?
Your Lordship, any other date will be given, maybe next week, Tuesday or then.
Passover sought by the Land Council for the petitioner, but the Land Council for the respondent states that she would be in the meeting. Matters accordingly adjourned. List on. This will take some time.
It takes some time. We'll take a lot of.
You say that it's covered though.
Yes, Your Lordship,
Yes,
have
my lord.
judgments in our favor. Your Lordship, Your Lordship, it will take some time. There are plenty of judgments.
Then we'll give you a Tuesday.
In case there is a negligence.
Third February.
Constitution, then like.
Read it.
Please, Your Lordships.
Yes.
Madam, in fact, this raises an interesting and an important question which Your Lordships had actually summarized while issuing notice in the matter, my lords. And what arises for Your Lordships' kind consideration is the issue that
What happened to the order? It's come?
none of the plan has been approved.
Resolution
So
plan.
that's the plan has been approved. Now, I'm really not even concerned with it, my lords.
You want to set off during the
Only,
application?
my lords, and may I only add, I am not for a minute even suggesting the law is no longer the issue of that even if an arbitration proceeding were to decide an issue, it cannot alter the plan. Your lordships have said two things: the arbitration proceedings can go on, but they will in no way alter the plan, because as far as the IBC is concerned, that will have an overriding effect.
So, Call, it's better perhaps we take up this matter on another day, Wednesday or.
Very well, my lords, whatever your lordship says.
Sorry, today is a Wednesday. So,
because
but we've got a crowd
My lords,
call because of the West Bengal matter.
I appreciate that. All that I am requesting is, my lords, if your lordships could consider any Wednesday for the matter that it has some bearing on the larger issues. And secondly, other than that, my relief is very limited. I am neither saying that I will claim anything against the corporate debtor even if I were to succeed. So I am not on the alteration of the plan at all. My limited relief is that it can't happen that you don't give me a value to my claim in the IBC. The corporate debtor proceeds against me in the arbitration, and I, even to the limited extent of a set-off being claimed in an arbitration, can't claim that. And even when your lordships dealt with the judgment of Airtel, where your lordship said set-off in an IBC. Mine is not a set-off in an IBC. I'm claiming it in the arbitral proceeding. Even in an IBC, your lordship said that ordinarily no set-off, but if it's a contractual set-off, or it is so equitably intertwined in the same contract, the two transactions, that we can look at even under the IBC. In Airtel, it was held to be two separate contracts between SL and Airtel. But I'm not even claiming that. It's not that I filed a claim saying that you owe me 20, I owe you 100, so 80 is the figure. I'm just saying that let my set-off be there so that if I succeed and my claim is more than yours, I don't enforce it. But if you succeed against me as the corporate debtor or as the resolution applicant, then if my claim is 50 and yours is 100, I get a set-off of 50 and you can only claim and execute 50 against me. That's the broad issue.
The broad issue is when there are concurrent findings of court, your lordships, including in the recent BPSL judgment, which we both were on the same side, have said not to interfere. notice of arbitration, this is already raised in arbitration. It's an indirect way of not touching a.
Well, the same thing was said on the first date of concurrent issues. I said with some, no, you are pointing out what was already pointed out. And on the first day, my lord, the Chief Justice.
We'll take it up on another.
Yes, very well, ma'am.
Another Wednesday.
Yes. Another Wednesday.
Another Wednesday.
Another Wednesday. When the court is a little less crowded so that you won't have to sweat. Though it's winter, I think already the temperatures are rising. So.
My lords, would your lordships be kind enough to give a specific date?
We'll give you a specific date. Do you want it this side or that side?
January, my lord?
January, yes. 21st January.
Grateful.
This for hearing on.
21st? My lords, could it be a week later or a week earlier, whatever you know?
28th.
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 Grateful.
18.
या तो मुझे एक हफ्ता बाद दे दो या एक हफ्ता पहले दे दो।
Not complete. By the time service is completed in one matter, one more fresh matter is added. So there's again an issue of notice.
May I suggest? They are all.
Obviously, you keep on filing more and more cases. When will the matter ever be heard?
We are doing that the same law, but by that time
You file a fresh case again. Now that
no
item which has been tagged, that's against state of Kerala. State of Kerala.
I'm 23.
So you have a batch of cases and you're bringing each one into the pipeline now.
Installments.
So by the time the service is completed in the first one, there's a last one which is added where the service will have to be completed. Unless, and they're all tagged together, we can't take up the matter for even hearing on interim relief without.
But below, one matter, if it is notice complete, we can take it up.
Sorry?
If one matter notice is complete below.
No.
Otherwise,
but they're all tagged together.
That's right.
Once they are tagged, we can't grant an interim order in relation to a matter where notice is yet to be served.
The threat of a contempt.
That is not possible. So, stop filing, perhaps complete service, then we can hear it. Don't file any more now.
Let us see.
Please wait till you finish your arguments on the interim relief, thereafter.
I understand.
So, as per the office report, dated, just with the date. Service remains incomplete in some of these matters. Steps shall be taken to complete service in relation to the unserved response. This on 4th February. 4th February.
Can it be January middle so that
you have to complete service. There are quite a lot of respondents there.
We are taking all effort below. That's this is we are doing it.
21st January.
Oblige.
Lord, we beg to appear in.
19, take up each matter separately.
Yes.
So all of you don't have to start shouting at the same time.
Yes.
It's the only way.
Each item, one at a time.
Very well.
So first 19.
19.
May I please start?
19
Vivek
is a
Paria.
Yes. Vivek Paria.
In this matter,
now
the process has
the grievance in this was that the new rules were sought to be applied to the
45
unpaid candidates. And we granted an
we were permitted to participate. Now the results have come yesterday, and the procedure as per the schedule as fixed has been concluded. May I suggest, my lord, this matter may be called up after the procedure.
Why should we keep it though?
No, my lord. The reason is this, my lords.
This is a different one. Arunima Paul was, I think, a little different because there, I think she was one of the tainted they come out with fresh food.
Announce your result. Your interviews will go.
We want to establish two people. That will be 50%. So they wanted to apply the listing and say that you're not eligible. So what he said,
এখানে এসএলপি তে আমরা রেসপন্ডেন্ট কোথাও নেই এসএলপি হচ্ছে
Correct, it has to be a finalized clarification.
And judge there, JB, seems to be entertaining the petition. And with the number, so it's going to place as some of the cases in the public. And the list of pages is not being put in the public domain already. We should look into that. So in the first place, the legislation will help us framing laws to ensure that changing candidates don't come here. If the is taking on such matters, we don't have to keep this. So you let the
Lordships on 21st August 2025.
There's one aspect though.
Yes.
The reason why we kept it pending was
Because
to see that tainted candidates don't slip
eliminated.
Don't slip through. Now we find that the High Court has taken up that issue in a writ petition, which is
No, my lord,
pending.
the scope of the proceedings in the High Court is slightly different. We were all people who were allowed to.
This issue is also being looked into as to whether tainted candidates have gotten.
My lord,
That issue is
That order is there.
no, my lord. The other issue, may I just clarify? My lord, there is
He already said that all of you will not speak at the same time.
Lordship, the High Court is in season of a matter where those who are not eligible under Lordship's direction.
All issues seem to be there. We will say that the High Court will look into
No, my
all
lord,
issues.
what would happen then
It
is.
would be better that the High Court, being the court of first instance, looks into it. The only
No, but
reason we
Lordship,
kept
my
this
what-
matter pending
Lordship,
was at that point of time, the High Court was not seized.
No,
of
my
it.
lord, insofar as.
Now the High Court is seized of a matter where this issue is
No, my
also
lord,
being
this
raised.
issue, qua
Last item.
Lordship's 20. Lordships would kindly see the. One the going.
Item 20.
Item number 9.25.
Lordships would kindly see the IA that we filed. Lordships would kindly see.
It's better that the High Court decides all this matter. It should be counted, Lordship. Item number 19.25, Lordship. Mukleshwar Ahmed.
Lordships, may I just place this one?
One more.
We have moved an IA in this case, moving on record a summary of the issues before the High Court. Because the earlier challenge was on multiple fold by tainted candidates also. And the.
Candidates which means will not be permitted to participate. Here the statement is published in such a manner that they are going to. If you look at the order passed by Justice Amrita Sinha, if you look at that order,
Lordships.
attention of this court has been drawn to the order passed by the Honorable Court, wherein there is a specific direction that candidates whose names appear in the list of tainted candidates will not be permitted to participate in the recruitment process. Prayer has been made to direct the Commission to publish the tainted list in such a manner so that the identity of the candidates can be properly ascertained. So this issue is being looked into.
But will another.
So far as the tainted candidates.
Our tainted candidates, this is our special leave petition. Look, kindly see, this is.
We will not interdict the High Court from looking into all issues.
No.
Only
My
whatever issues the High Court.
My lord, that
will
is
into,
correct.
and only High Court.
Our petition.
One issue
This
here,
is our.
because I appeared before the High Court. There is one set of issues which pertains to tainted, untainted, so on and so forth. The
This is our.
second set of issues which your lordships have already taken note of and adjudicated upon is prior weightage, meaning 10 marks prior teaching.
That is not even before.
Yes, no.
That was what the High Court
Said you will not apply the new rules to the
Yes, my lords.
untainted
Yes.
candidates,
Yes.
so as to keep them out as
Your
the.
lordships will clarify that.
High Court only considering the constitutionality of the new rules.
Yes,
By
but
what
your
you are
lordships-
interim on.
Any will also get the weightage mark.
Can I pass on? Can I pass on?
stage of
Subsequent
benefit
order?
is
No, but the High Court is
Yes, my lord.
considering the
Yeah,
constitutional
Stage
validity.
of the one.
That cannot be
Be
interdicted at
qualified
this
for
stage.
calling for interview or add it
Yes.
only at the stage of
These
interview.
two
So we get
questions.
filtered out.
My lord, cited by the High Court.
Not even at the inception.
But
No,
all,
now that the High Court is seized of actually, how many matters are?
My lord, kindly.
my lord,
Our.
You know, why are they scared of going to High Court? I don't know.
My lord, this is our special leave
your lord,
petition.
if you could just
My lord,
pass
kindly.
We are not going
No.
to stop the High Court.
No. I am not. But there is a finding, kindly see. Hello, excuse me, sir. There is a clear finding that the physically disabled persons who are in the tainted list, they will not be allowed to appear in the examination. But your lordships have said something else in your lordship's judgment. Kindly see.
We have never said any tainted candidate will be allowed.
Physically disabled.
Physically disabled, untainted candidate. I remember distinctly, Dr. Mukhiddar appeared.
Yes.
Yes,
Lordship.
Tainted
Number
means tainted.
19.25.
They stand on the same
Candidates.
as that what
OBC
Can I place that paragraph to your lordship? Kindly see.
If you get the benefit of 7 years
Kindly come to page
job.
68.
The High Court is interpreting the order.
Page 68.
Yes, paragraph number.
Page 68.
Yes.
Paragraph 47. First I read, then paragraph 48. Some of the appointed candidates who do not fall in the category of tainted candidates may have previously
What is the other issue? That is with regard to going back to the.
Kindly come to page 48. Paragraph 48. Later we address the case of disabled candidates. Our attention has been drawn to such cases where the improved judgment held that the appointee Mr. Somadar shall be allowed to continue on humanitarian ground while we will not interfere with the findings. We will make it clear that other differently capable will not be entitled to same benefit as would contradict legal principles. So, however, in consideration of disability, these candidates will be permitted to continue and will receive wages until fresh selection. Next, paragraph 49. These disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. But if your lordship,
Next sentence.
similarly, other candidates
This is similarly indicates that
Tainted cannot appear, whether disabled label is immaterial.
That whatever you
This
lordship,
sentence
we have no other.
Deep level.
One request
Lordship
that this issue
of
of
the disabled candidates is
Allow
provide
for
for
2 minutes.
No.
Item number
one request that
Provide, I have
this 10 marks may not be
When
real.
all parties are before the High Court and the High
again
Court.
and again before the High Court to bring in the tainted candidate. We do not understand why.
High Court is not, High Court is not
because
listening.
our interpretation we have done it.
All these cases we are going to close.
At least this candidate, Professor Emma, should get the
Well,
7
let the
years
High Court
benefit.
decide. All issues you raise,
Because examination is over there.
all issues you can raise before.
Lordships have already adjudicated.
We are not going to have parallel proceedings.
I have one.
He was appointed with the due process of law.
Prior experience,
Sorry,
the High Court by
That
looking
High
at
Court
prior
will decide.
experience again.
that is a different issue. It does not come.
But you have not.
Yes.
Judgment.
High Court is considering the constitutional validity, not the same thing.
One of so far as
We are closing all matters.
here we
Lordship, kindly
here
take all these
You are the villain of the piece.
one thing I have made.
Don't allow to High Court adjudicating Lordship.
There was a findings division bench regarding the teaching experience which has been given, that has been sanctioned by the division bench. Then one Orunima Pal was the unsuccessful candidate.
She was a tainted candidate.
No, why the School Service Commission is interested in this matter?
Opposing everything against that.
Arunima Paul, I dismissed. I didn't.
No.
Yes.
Exactly.
Why the SSC is so much concerned?
Exactly, I'm saying that. Kindly just
Lordship,
hear me for 2 minutes.
19.25, I take
Orunima
untied Lordship from this.
who was unsuccessful in 2016 selection process.
But she was not even selected.
Yes.
Not been selected. Now, in 2025, he challenged that. Against that.
Perhaps you have changed.
What is that? No. Please, kindly allow. No. Why?
No, the High Court is considering the constitutionality of the rules.
Kindly,
Let the High Court decide the matter.
kindly just hear me,
You know
Millard.
the decibel levels work at the Supreme Court.
Millard, kindly just hear me, Millard. Just 2 minutes.
Yes.
Without any interruption. Then your lordship will dismiss my contents. I have no difficulty.
2 minutes, start now.
2 minutes, just 2 minutes.
Yes.
Unsuccessful. 2016, 2025, they sat. They became again unsuccessful. They challenged the division bench judgment, where the division bench upheld the provisions of the teaching experience, right? And against that, SLP has been filed. Your lordship dismissed that. Therefore, those who are saying
You
about
need to also see what the locus of that person was.
no.
We did not
Yes.
say anything on the merits of the matter.
So,
So mere dismissal of the matter does not mean that all principles in that judgment have been upheld.
yes.
Because therefore, all of you go back to the High Court.
Lordships are not deciding the para 47. Para 47, we are on the next category. We are not on the para 47.
You've been allowed to join, is it?
No, I have a small request.
They can argue before the High Court.
Applications are different. Let that not be disposed of by this order in 19.
47 is people who are wanting
One
to
set
go back
is
to
not
their earlier job.
joined already, one removed and then came back for this, my lord. Your lordship permitted them to go back to their respective departments.
Within the state of West Bengal.
Yes. Now, my lord, we represent about 30-40 people, my lord. What has happened with them is simultaneously, after they joined in this, my lord, simultaneously they got appointment orders from one other different department of the West Bengal itself. Since they have joined and there was no case pending at that point of time, they could not join the other department, but they continued here.
That's going beyond 40.
Now today I am left with no remedy. We are all age kind of candidate.
Does not cover that situation where
we want
offer of another job which you never joined.
There are vacancies.
We only permitted you to go back to the job that you left.
We are based similarly.
Yes.
Similarly.
Similarly,
Withdraw here and go back to the High Court.
That should be made. You won't say anything, whatever you wish to say before the High Court.
Please withdraw these plans.
Yes.
On High Court.
19.16, I'll withdraw.
19.15
and 16.
19.15,
Liberty.
19.1.
All of us will say that, Lord. Same order.
Moana, which one do you want?
19.9 to 19.23. I appeal.
19.9
to 19.
All of them.
Yes.
All of them. With
liberty to
approach the High Court. For the same relief.
For seeking redressal.
Also, one more thing, not that findings in the judgment of the court should not come in the way.
Yes. We won't say anything.
19.1, 19.8 also.
19.1.
All same one.
19.15 and 16. 19.15 and 19.16.
19.38. 19.38.
19.27, my lord.
19.27.
Just there is one clarification, my lord, would be needed because now after the result, they have published a list only by name. And the list of tainted candidates are there. Now it is very difficult to find out.
High Court is seized of that.
Lordship, we just
once the High Court is seized of that issue, then
one suggestion on the High Court. On the High Court,
we'll make a
Lordship in November 23 had 19.27.
Yes, Ms. Makina.
Lordships have said that 31st December the exercise must finish, your lordships. Now, unfortunately, I've just given this list. There are more than 70 matters which have been filed in the High Court.
That, of course, will not do.
Lordships, let me finish. Where different aspects, there's hair splitting, different aspects are being challenged. I have no problems in the matters remaining pending. All that I'm saying to your lordships is that matters can go on. But let no interim orders be passed.
Yes.
Court hasn't passed any interim order. Why is that? Court hasn't passed any interim order. Honorable Supreme Court cannot be.
Tainted candidates have gotten through. They can't get
Yes. No tainted candidate.
No.
Other matters which need to be withdrawn.
On the High Court.
Withdrawal matters anymore.
Now we will get decision more.
19.25, Lordship. 19.25.
Now we will decision.
If you want to withdraw, say so. No, you're not pursuing it here.
Para 47 of the Lordships.
Para 47 orders have already been implemented.
I'm working in the autonomous body in Kendriya Vidyalaya Sansthan. They are not.
Where are you?
Bengal.
Why is he not returned to his?
No, no, we have given everyone. We have
He's
given.
in Kendriya Vidyalaya.
Central government is not our
government. Central government perhaps is not a party. We have only said the government, which means the state government. State government and autonomous body. Autonomous body, Kendriya Vidyalaya is a central government organization. It's not an autonomous body. It is not an autonomous body.
Under Plus, on going back to the High Court, may I make a suggestion, Milos? Your Lordships in November 23, when your
It's a
Lordships
different
passed
issue
order.
now. You'll have to go back to
There
the
are a lot of matters that your Lordships can see. There are a lot of matters, a lot of issues. Your Lordships want to send everything back to the High Court. Very well. Because in November 23, when my Lords had passed a similar order at the interim stage, my Lords had said go before division bench and hear it expeditiously. My Lords may pass a similar order this time, so the matter can be heard finally.
No, no, no.
Just one prayer, my lord.
That's all now. Let us dictate the order.
Pass
The order.
Yes.
Your Lordship, will your Lordship be,
You should continue,
pleased to
my
take up the
lord.
intervention applications in item
You should
19?
be permitted to continue, my lord, till the time our case is not.
No further order, no further order. High Court will please
All issues you address
will be heard by the High Court.
Yes.
Will your Lordship be pleased to take up the intervention applications, Your Lordship, in item 19?
go before the High Court. By this, because we blend the state government and bodies which come under the state government.
No, just 1 minute, my lord. High Court, I go there. But we will approach the High Court in 2 weeks' time. Kindly protect us.
Your Lordship,
2 weeks, kindly give us protection.
Your Lordship,
Approach the High Court.
will your Lordship be pleased to take up the intervention applications in item 19, Your Lordship?
88 of 2025 has already been entertained by a learned judge of the Calcutta High Court, and various issues were flagged by the learned judge in the order. What is the date of this order?
Lordships, there are various orders, your lordship.
19/11/2025.
Yes.
The matters pending before this court as on date were kept. The matters on pending.
My lord, and
Matters on file before this court as on date were kept pending. You got the sentence. The matters on the file of this court as on date were kept pending only for the purpose of verifying as to whether or not the directions of this court in the judgment dated 3/4/2025 in state of West Bengal versus Baisakhi were being implemented scrupulously. As we now find that a learned judge of the Calcutta High Court has taken up that issue, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertakes this exercise instead of this court.
Yes.
It would be open to all the petitioners, public applicants before this court to approach the High Court for redressal of their grievances.
Yes, ma'am.
In accordance with law.
However, the selection process which is underway will not be stopped, your lordships.
We will not say anything.
Nothing.
What
What sort of prayer is made?
Direction, that
We have fixed the time frame. As and when they come with an extension petition, then you can.
Yes. Stop to any selection.
I'm deeply obliged.
Will your Lordship be kind enough to take up the intervention applications, Your Lordship, in treatment applications in item 19?
Through. None of the tainted candidates are permitted to slip through
11th November, 12th November.
during the fresh selection, be it on one pretext or the other. The High Court shall also ensure that the list of tainted candidates is placed in the public domain.
Yes. Yes.
With full details. With full details.
Grateful, grateful.
So as to ensure that
And
this does not happen.
candidates should get the benefit of 7 years.
Your lordships, it will be Lordships to say that it should not be stopped.
When it comes to seek to read more into certain aspects of the judgment dated 3/4/2025 would also be at liberty to raise such hermeneutics, HERMENEUTICS, before the High Court
Your Lordship has said that.
Your Lordships have referred to an earlier the single judge's order. Well, against that, there are several other orders. There is an order of 12th of November. 19th
November.
7th November. And 11th November.
I want those also. Same learned judge. 11th November, 12th November, 19th November.
11th November, 12th, and
20th November.
In those orders also issues have been flagged.
All issues and all.
7th, 12th and 19th.
7th, 11th, 12th.
7th, 11th, 12th and 19th.
And the judge is hearing all the issues.
Candidates of successful candidates also, so that it can be compared, right?
7, 11, 12,
Compare this.
Compare what?
7, 11.
Those who have succeeded in the exam.
19.
Why would we want the untainted candidates to be looked at? That's unnecessary.
Able to know.
Unless the High Court is now on a time frame, they have to complete it as.
The matter is fixed on 28.
Lordship, be kind enough to take up the intervention applications, Your Lordship.
And the applications
Yes.
are disposed of in the.
Keep low. Keep low, please.
Consider saying uninfluenced in our future.
This will ultimately bring everything to question.
High Court can look into it. Matters uninfluenced by
Yes.
any of the observations on merits made by this court in the earlier orders.
And one more line, not to kindly add one more line.
Now get out of.
We've already discussed as withdrawn various matters. You want to withdraw?
Lordship, these are the cancer patients. We have claimed the similar relief orders on humanitarian grounds.
That was refused by the court.
Cancer patients and all that. We only said dealt with physically disabled candidates. Soma Das was a blind. Cancer and blind. She was a physically
The
disabled.
court categorically held Soma Das case will not be applicable.
She was a physically disabled candidate too. She might have had cancer also, but she was within our scope only as a physically disabled candidate.
Because the matter is listed day after. This order may be uploaded today. It's listed day after.
Uploaded today.
Very great.
So far as
Keep low.
go before the High Court, please.
Extremely obliged to the Honorable Court.
If Your Lordship may be kind enough, Your Lordship, in item 19.
Go before the High Court.
Now vacate.
Already given
Space
that.
for others. My lords, your court will now empty out. My lords.
Yes.
Lordship, insofar as.
Your Lordship, in item 19, the intervention applications.
Actually, the first item, we were permitted to participate on account of the old qualification 45. Lordships may clarify that
You've already challenged those rules.
No. We repelled by the High Court. We succeeded in an appeal and then we are here, my lords.
The High Court shall also be mindful of the fact that the
21st August
candidates during the past selection were allowed to sit for the exams.
In terms of this court.
For the selections afresh, to be held afresh, and their candidature cannot be adversely affected by application of the new rules.
Excellent. Grateful. And one more line, Lordship. I want to the
untainted candidates would be
Untainted candidates. They have examinations.
These untainted candidates will get the benefit of 7 years.
Read them out.
No. Why?
They have appointed.
Therefore, Lordship may retain this matter.
You come up with these new rules and you try to.
And they were permanent in their job.
Because of
Kindly add this
our order, there is
Kind, yes.
Item 19 may be retained, my lord.
And 20 also. My lords.
Not this anywhere.
In item number 19.25.
We have given 10 marks for experience.
you will be giving them all 10. All the teachers, untainted teachers, will be having them.
We are all untainted.
At what stage?
Will you be giving 10 marks to all?
10 marks if he has
Weighted.
for first year 2 marks. If they completed 5 years, 10 marks.
Well, 2019 was. All of them have 5 years.
Yes, now we want.
Yes,
That is the reason why we asked them, you are benefited by this.
No.
Yes. We want
Decibel is that side higher.
No, my lord,
For once.
now
You have the microphone.
now what has happened?
Can never.
What has happened in the written examination? Some of the untainted teachers have secured only 26 and 30 marks.
And 7.
So they get these 10 marks though.
Even they have added 10 marks.
Yeah.
Even the educational qualification 10 marks. Even in that case,
If
they
they
are
are
less.
not selected, they're not
They are
selected.
less than fresh candidates. Yes, marks are less than fresh
We are
candidates.
not.
No, therefore, if a lot to say that all untainted teachers have to be allowed, then it is.
We have not said they will be allowed. We
They
said that
cannot
you
be
will
disqualified.
not adversely affect them with the
Previous
application
experience
of
should be counted, Lordship.
this 50%, 45% you cannot apply.
Yes, yes.
Too much. This is too wide because freshers are also coming within this commission. Arey bhai, what?
सर आपको समझ में नहीं आया मेरे को.
But this new rules will be applied also to the freshers.
No. New rules will not be. See,
To me,
yes,
freshers
when we asked you to undertake the selection of fresh, we did not contemplate that we will add new vacancies and bring in fresh.
Yes.
The intention was that you could hold a fresh selection for these untainted.
Yes,
You
but
enlarged the scope
Lordship,
now. You brought
Lordship,
fresh vacancies.
untainted candidates, Lordship.
So
Their
you asked
previous
for this
benefit should be
on
added,
top of
Lordship.
that, you bring in new rules. Then, once you bring in new rules, it can only apply to new selectees. It
That
cannot
High Court
apply to
is
these people
pending.
whose selection has been set aside and they've been given another go.
But your
That doesn't mean that you apply the new rules to them.
But your lordships have said to appear in the
Namala, let this matters be now argued before the High Court. Why he is
selection
wasting?
would start. Fresh
Giving of
selection
10
means
marks to
examination.
untainted
If
candidate,
an
that is
examination, a selected candidate, the untainted
When
candidate
did you ask
should be
us for
added, Lordship.
permission to frame new rules and apply it to the
Yes,
untainted candidates?
to create all trouble.
Did you ask for that?
Well, they have. We have.
You've done that. So far as these untainted candidates are concerned, their candidature shall not be adversely affected
Yes.
by application of these new rules.
Mother, then in that case,
Deeply obliged.
that
Greatly obliged. Greatly obliged.
candidates who has secured lesser marks than the first team.
That selection, whatever you wish
That
to do, you do that.
is go by the rules. Go by the rules. It doesn't go by the interpretation.
Clarify that.
That is all. That is all.
As such,
That's all, that's all.
Test after 10 years.
That's all.
Yes.
That's
Lordship, in item 19, Your Lordship.
High Court is considering the matter. Let the High Court do it.
Nothing. We've said that the untainted candidates.
Lordship, kindly add one line, Lordship, in order. Their previous. My Lord will not.
Lordship, item 19, Lordship.
End it now.
Your Lordship, I have an intervention application, Lordship, in item 19.
About it, and then also obviously come back to me.
We all want to be heard by your lordship, my lords, always.
No.
Always want to be heard.
We've not said anything about that. Why should she say anything? You sensitize the High Court that they are great.
I am ready, whatever your lordship says. I think your lordship declared that all tainted candidates will be taken into the employment.
Tainted candidates.
Untainted.
You said tainted.
Mother, whatever is there in the order. No further clarification is necessary. It should be a separate hearing, Lordship.
No.
You didn't say untainted.
Untainted. If your lordship desire that.
Well, SSC is much interested to see that the corruption again picked up.
In a competition, they are lesser marks.
In fact, not they should have held a separate selection for us. They didn't do it actually.
Next matter.
Your Lordship, in item.
Because we are grateful, my lords.
Next matter. Yes.
Appearance be given physically.
Yes.
Grateful. 7 maybe. Grateful.
19.37 also. 0.38. 38. Oh, he doesn't want this person. 37. 27.
24 is of the same one.
24, you want to withdraw?
No, this is the same one.
Same one. 24, same one.
20. 20 council has come in or still battling at the door?
What is empty now?
Yes.
And no more sweat, your lord.
But then what Mr. Gopal Subramaniam is equal to all of us.
Now you'll be elegantly addressed by Mr. Subramaniam, my lords.
That's why I said one is equal to all.
And the football rabble-rousers are going to leave, my lord.
Sorry?
The football rabble-rousers. My lord, we gave you the atmosphere of Mohan Bagan versus Mohammed Al-Spotted. It was like you were in West Bengal. Grateful, my lord.
Yes, 20. Yes.
Please, your lordships. Look, the issue is a short one as far as the.
It wouldn't be short with you appearing, Mr. Subramanian.
Not, I try to be as concise as possible.
There are cross appeals, my lord.
Yes.
One issue, my lord, they have succeeded on the other issue, my lord, we have succeeded, my lord.
Yeah.
Lord, there are two appeals.
Yes.
That is Civil Appeal 9701
Yes.
of 2025. Lord, I beg to appear for the appellant in that appeal.
Yes.
The companion appeal is Civil Appeal 12367 of 2025, which is, my lord, the appeal which my learned friend Mr. Mehta referred to, where, my lord, my learned colleague Mr. Sibbal appears on behalf of the very same party. Respondent. Yes.
For the respondent. Yes.
My lord, the judge, this present appeal, my lord, is directed against the judgment of the National Company Law Appellate Tribunal of the 24th of January 2024. And in substance, my lord, it affirms the order passed by the National Company Law Tribunal, which rejected, my lord, the petition under Section 7 of the Insolvency Code.
Lord, one small interjection, if you lordship permit mine. Lord, I respectfully submit, my lord, the question which is answered against us, my lord. Just give me a second. If, my lord, we address your lordship on that point, my lord, the issue, my lord, which is decided against them will become irrelevant. So in case your lordships would like to hear that point first, I leave it to your lordships, my lord.
But may I just set out my facts, then I'll be in your lordship's hands. Let me lay out the facts,
Good.
and then after that, Lord, your lordships may take over. My lord, let me straight away bring to your lordship's attention what happened in this case. My lord, there are two entities who are involved in this matter. One of them, my lord, is called ESL, and the other, my lord, is ECL. I'm just, my lord, using an acronym for the purpose of convenience.
Yes.
My lord, ESL, if your lordships will see, it has a slightly longer name.
Electro steels.
That's right, my lord. Your lordships will notice that it is Electro Steels Limited, ESL, which is the principal borrower.
Yes.
Electro Steel Castings Limited is, my lord, the party whom I am pursuing.
Yes.
And according to me, my lord, it is a guarantor. And there exists, my lord, a contract of guarantee, which can be subjected to the regime in the IBC. So, my lord, everything really revolves around the question whether there is such a relationship as a guarantor, whether a contract of guarantee is discernible, and if it is so, then, my lord, logically, the applications are maintainable. The NCLT, my lord, came to the conclusion, after examining the various documents in question, that a contract of guarantee was not made out, and therefore the application was incompetent. My lord, in the appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal, my lord, concurs with that for slightly different reasons, but, my lord, reverses a finding and says that, in fact, there is no extinguishment of liability on account of the resolution plan, because, my lord, various reservations are contained in a resolution plan that this does not in any way impact or impinge upon the liability of a guarantor, liability towards a guarantor. Well, this is just the broad view which I wanted to place for your lordship's consideration. Now, my lord, let me place some documents
Because ultimately, my lord, under section 126 of the Contract Act, we have to examine, my lord, what is the law and how has it been defined. My lord, I must say, there is a distinction which is often drawn between guarantees which are called on-demand guarantees, like, my lord, bank guarantees, which on site you are meant to pay the money, which is guaranteed. And you also have, my lord, what are called guarantees, which really are intended to ensure the performance of an obligation. These, my lord, are colloquially called in English judgments as to see guarantees. That is, you ensure the performance of an obligation on whose behalf you are an obligor. So, my lord, the expression obligor or the word guarantor, my lord, these are all words. But ultimately, your lordships would have to see that is there an element of undertaking? Is there an element of voluntariness? That in the event that there is a default, then this person will do what is required to remedy the situation, that that person will not be in default. So, my lord, if the extent, if I may say so, of assistance or obligation which is undertaken by the obligor is coextensive with what was the obligation under the contract of the principal borrower, then, my lord, it amounts to a guarantee. Now, my lord, this is the real question which arises. My lord, there is a recent pronouncement of this court. There was a question, my lord, again under the IBC. There, my lord, it was styled as a deed of hypothecation. And the court examined the question. It may be christened as a deed of hypothecation, but if it has the constituent elements of section 126, we will not hesitate to treat it as a contract of guarantee. So, my lord, it appears from, I'm just stating the principle, I will make it good with reference to many of these judgments, but, my lord, it is, suffice it to say, the nomenclature, my lord, does not really decide the issue. It is the constitutive elements of a guarantee which must be discernible, and if they are discernible, then, my lord, notwithstanding, shall we say, a pleading, notwithstanding for the matter of fact, my lord, something said which is inconsistent with it may not necessarily decide the issue. It is, my lord, preponderant evidence of the presence of these elements which will lead to the existence of a contract of guarantee. Now, my lord, that's the burden which I have to take for the purpose of succeeding in this appeal.
Yes.
So, my lord, may I take your lordships to the various documents, because I will take them in a chronological manner, and your lordships will then come to a view whether they militate against the existence of a guarantee. Well, the first document is Annexure A2, which is the sanction letter, which your lordships will find is in volume 1, your lordships printed page 204.
Yes.
So, my lord, I'm using a soft copy, but I have also noted down in the notebook, my lord.
We are old timers. We use hard copies.
That might be.
So just add, my friend said he laid down the facts.
Oh, Mr. Mehta has vanished.
No, he'll be here. He'll be here. It is better to first note who was the debtor.
Yes.
What was the resolution plan? What did it say about the debt? Does the debt survive after the resolution plan? Because you will go to a guarantee only if the debt survives. So it is one of our points that once the debt is fully discharged, extinguished, there's no question whether you have or you don't have. So it may be better if you first start with the fact as to who is the debtor. My friend is an assignee of a creditor who was a part of the plan. It's better to probably look at those facts. I can.
May I say, my lord, each one has his own rhythm.
It's okay, but
my learned friend may take it. I will
We
certainly.
are aware of those facts, Mr.
no, otherwise
you
are going straight to a guarantee without seeing what the debt is.
You're aware of the fact that he's an assignee of
So, yeah.
SREI.
Nothing is going to be missed. I assure my friend that nothing will be missed.
SREI is a short form or the name itself is SREI?
No, my lord, it is got a slightly. SREI Infrastructure Finance Limited.
But SREI is the name by
Yes,
itself.
yes,
SREI.
that's the name.
I thought it was a short form for something else.
So, my lord,
also
first,
IBC.
They're also in IB.
Yeah.
my instructing attorney says that they have fortunately come out of the IBC.
Come out of it.
Yes. They were in IBC.
Now, my lord, let me take the first document, that is page 204. This is, my lord, the foundational document, which is the sanction letter. And this, my lord, your lordships will notice, is addressed to the principal borrower, Electro Steels Limited.
Yes.
We write with reference to your aforementioned proposal and subsequent discussions on the subject. We are glad to convey our final approval for a rupee term loan for the above, as per the terms and conditions set out in Annexure 1, which are indicative and not exhaustive. The above facility is also subject to the terms and conditions to be enshrined in the loan agreement and other transaction documents, agreements, financing documents to be executed at a later date. Well, the reason why I'm reading this para is that as an assignee, well, ultimately I was an assignee. The assignee, in fact, assignment took place after the sanction of the resolution plan.
Yes.
And according to me, Malot, I'm a valid assignee and I have to derive my rights in terms of the underlying documents. Now, Malot, after this, if your lordships would be good enough to see further, Malot, at the bottom of this, there's a reference at printed page 207 to two annexures, Annexure 1 and Annexure 2. 207.
Yes.
Then, Malot, we now look at the annexure, which is the term sheet. Your lordships will find the term sheet printed page 208. Facility amount, rupee loan commitment, rupees 500 crores only. Your lordships will find that.
Yes.
That is, Malot, the facility which has been given by this sanction letter.
Right.
Thereafter, if your lordships will now come to the next, please come to printed page, Malot, 222.
22. Yes.
Your lordships will notice on the left-hand column, promoters, sponsors, partners, undertaking. Now, my lord, I submit with respect that as far as ECL is concerned, my lord, the person whom I am pursuing as a guarantor actually is a promoter within the definition, my lord. And this promoter, sponsors, partner shall furnish an undertaking that the promoter, sponsor shall not without the prior written approval of SREI transfer, assign, dispose of, or pledge, charge or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed prior to the date of first disbursement. To arrange for additional funds, now, my lord, please mark item 2. To arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun, if any. Number 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. Now, my lord, according to us, this is a substantial obligation, and your lordships will find this gets strengthened and strengthened as we go along. Now, my lord, the next document which I want to place for your lordship's kind consideration is the document which is dated. My lord, this is the sanction letter. There is another document which your lordships will find is at printed page.
Do you ask for any acknowledgement of these terms? Or
no, my lord, this is what they wrote. This is the first. After this, your lordship.
This is SREI's letter to Electro Steels.
That's right. Now,
so do you,
this is
do
what
you also ask for some
it has been
acknowledgement from them?
Yes, yes. Not only that. Now, please kindly see, there are further agreements. Yes. Let me now show, my lord. Please come to printed page 248.
Yes.
This document, my lord, begins at 247.
Yes.
Please see. This is in pursuance of our sanction letter dated 26th of July 2011, bearing reference number so-and-so, sanction letter wherein we had conveyed our approval for extending to you
Do you also have a list of dates or?
I have.
Sanctions or-
I have. I'll hand them over. Yes, certainly. Just get out, Mr. The one. Okay. Get the list of dates. We'll just, my lord. Please see, my lord, at page 2, printed page 247.
Yes.
This is a second letter of the same date.
Yes.
And please see, we would like to inform you that after conducting due diligence of the project and further discussions with you, in addition to the terms and conditions set out in the sanction letter, we shall require you to provide such additional security as stipulated hereunder. And your lordships will notice at the bottom of that page, we would like to further confirm that as on date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal or corporate guarantee from Electro Steel Castings Limited is required for securing the facility. Now, my lord, this sentence, this one sentence is being, my lord, actually used, repeatedly relied upon to say that there is no corporate guarantee because of this sentence. But, my lord, really, if one reads the tense of that sentence, it says this as on date, that is, as on that date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal is required.
Who is he?
My lord, he happens to be the promoter and managing director of the group, my lord. This gentleman, Mr. Kejriwal. Or corporate guarantee from Electro Steel Castings is required for securing the facility. So, my lord, it was not a condition precedent on that date. Now, we will see how things develop thereafter to determine whether there is a guarantee. As on that date, it was not required. That's fair. But, my lord, this does not in any way, if I may say so, impinge upon documents which are executed later, actions and transactions which actually suggest that, my lord, ECL undertook its obligations like a guarantor. Now, my lord, this is the document. Now, please see, your lordships will now come to the loan agreement itself, which is at printed page, my lord, 250.
Second volume.
And in this, if your lordships will notice, this is the loan agreement. In the loan agreement, my lord, the parties are.
Yes.
It's still, I suppose, my lord, the first volume.
Sorry? It's the second volume.
I think.
Rupee loan agreement.
Yes.
Yeah.
This, my lord, is the agreement.
Yeah.
This is dated, as your lordships will see, this is also dated 26th of July, 2011. And please see, my lord, the parties are SREI and Electro Steels. Then please now come, my lord, straight away, as your lordships will see, after all the terms are properly defined, your lordships may kindly come to page, I'll just give my lord the printed page. This would be, yes, 386, my lord. Yes, I have that. 386.
Yes.
My lord, on this day, your lordships may also notice that ECL was having the largest percentage of shares in the principal debtor. And please now, principal borrower, promoters' undertakings. Does your lordship get that?
Yes.
At printed page 386. The promoter shall furnish an undertaking. Now, my lord, we have moved forward. Shall furnish an undertaking. The
What is the date of this agreement?
Well, this is also 26/11/2011.
Same day.
Yes,
Same day.
same day. 26th of July 2011.
So everything happens on the same day.
Yes, my lord.
Yes.
The promoter shall furnish an undertaking that the promoter's sponsor shall not, without the prior written approval of SREI, transfer, assign, dispose of, or pledge, or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed in the disclosure letter. Now, my lord, this first condition, which imposes a restriction upon your ability to deal with the shares in the borrower entity, is indeed a restriction. But this restriction, my lord, is only to indicate that there is a constituent obligation which is placed upon the guarantor, well, not subject to his being called a guarantor, to arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun and or gap in means of financing, if any. 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. This, my lord, is the obligation. After this, if your lordships will kindly go over to, my lord, please see printed page. Let me show, my lord, that is clause 6.3.1. That would be, my lord, at printed page 335.
330.
Yes, I just needed to show that, my lord. That's where the obligation lies.
Who signs this document though?
I'll just indicate, my lord. My lord, only the borrower and Shrey.
Where do we find that?
My lord, we'll find that, if your lordships will find. At page 466, my lord, printed page 466. It's just 416. 416, my lord, 416.
416.
Yes, at the bottom, your lordships.
There's no signatures there. It doesn't. 416 has both ESL as well as.
Yes, yes, my lord. Yes.
Is that part of this agreement or is that a separate document?
That's a separate document, but I'll give you the signature page, my lord. 378, my lord.
378. Signed and accepted.
Common seal of Electro Steels Limited, pursuant to the board of directors.
Borrower has cost.
Yes.
Very good. Page 3.
In the presence of so and so, authorized signatory of the borrower who has signed these.
We'll continue after lunch.
Certainly, my lord.
But we'll be a little late perhaps because we have a full court meeting today. We can't tell you how long we'll be.
But
you can have a cup of coffee, extra cup of coffee before you come back.
My lord, may I please mention item number 3, my lord. We want to withdraw it, my lord. Item number 3.
Number 3. 3 is passed over.
No, my lord.
Then?
The argument was heard, my lord.
And then
Senior has asked me.
dismiss.
Yes, ma'am.
We want to withdraw it after the event.
Item 3.
3.
Dismiss.
Right. He doesn't want the trial to be expedited.